case of People State of Michigan versus James Whitley.
No.
Typically, oh, go ahead.
Thank you. No full use on behalf of people.
Good afternoon, Your Honor. For the record, my name is Jeffrey Bennett, appeared with me, Mr. Whitley, sitting to my right.
Typically, the court doesn't publicly discuss, and I will apologize, Ms. Hughes, and I will allow certainly counsel to say what they want to say or need to say. The court doesn't discuss bench conferences, but I think under these circumstances, I'm going to certainly disclose that, unless Ms. Hughes, since it was your issue that you brought to the court, unless you have some strong objection to that.
I have no objection. Thank you.
The court has been informed that, at least alleged, that the defense counsel has indicated that should this exam begin, that it may be his intent.
Buckle up, guys. Today we are going to witness a courtroom moment that shifts from routine to explosive in seconds. As the judge opens the session, a quiet disclosure ripples through the room. The defense allegedly warned they might file a grievance against the prosecutor if the hearing proceeds. You can almost feel the tension snap as the judge pauses, realizing this isn't a small procedural hiccup, but a direct challenge to the integrity of the proceeding.
Grieve the elected prosecutor for pursuing this case. Court has some concerns with that. First and foremost, that posture in and of itself can have a chilling effect, not only on just proceedings and may be an attempt to interfere in these proceedings, which may in and of itself constitute a grievable offense, but also that this court, if that is indeed the allegation, would not proceed with a hearing that would require someone to then commit a grievable offense. And Ms. Hughes also disclosed to the court that she, in essence,
Here, the judge presses the defense hard, demanding clarity on whether they truly believe the prosecution is committing a grievable offense. The attorney hesitates, backtracks, and shifts tones, trying to explain the earlier accusation. This part is gripping because you can see the judge's patience thinning, while the defense scrambles to soften a statement that has already set off alarms. Inside the courtroom,
went up her chain of command to seek their advice as to what she should do. It was ultimately said, I think, at one point to certainly bring it to the court's attention, which I think is appropriate since it's under. Mr. Bennett, I will ask you whether or not you believe, in this case, that the people in proceeding are committing a grievable offense. And if so, for you to state on the record what that offense is.
My concern.
I'm not asking for your concern. I'm asking for, you have made an accusation that, know what?
I don't believe that they're committing a grievable offense.
Do you believe that in starting this exam, that they would be committing a grievable offense?
No.
Was that said to the prosecutor?
That was said, I don't believe it was said in the manner that was described at the bench, but certainly.
Then tell me how it was said.
Well, there were two things. One, at the bench, do you want me to ignore the one you didn't disclose?
Tell me how it was said.
What I said is that I believe that if the state were to go forward, that it would be grievable because I believe that the prosecutor is not following.
Tensions spike as the judge digs into the defense's shifting story. The attorney claims the prosecution ignored key facts, but then reverses, saying new information changes everything. The judge doesn't let up, questioning the logic and exposing cracks in the attorney's reasoning. This is where the power dynamic becomes undeniable. The judge is openly warning that the accusation itself may be the real misconduct.
Through under ethical obligations under the Michigan Rules of Professional Conduct.
Which ethical obligation are they not following for?
The two that I am concerned about are, one is determining what the actual facts are, and the two is prosecuting somebody who may in fact be actually innocent. What I did was I had offered Ms. Hughes, if she felt that it was appropriate, if she wanted to discuss the recanted note with the alleged victim. I said, why don't we could just adjourn this out and you can talk to her and decide how to go forward. So my only concern is that they didn't make contact with the alleged victim, who now has a different story, but I no longer believe that's a problem.
Does that, even as you describe it, amount to something that is grievable?
It doesn't. But
And why was it set?
because at the time I believed that it was grievous.
What changed?
Quite honestly, what changed is I wasn't aware at the time that they had the lay witness here. And so the presence of the lay witnesses, I think, eliminates all of the issues I had with the police providing the testimony that's admissible here, but not in front.
Ms. Hughes.
I absolutely intend on proceeding pursuant to MCL 76827C. I have made no statements to Mr. Bennett about Ms. Potter being present. But I don't think it is, because Ms. Potter is not present.
Explain to me, Mr. Bennett, how that makes a difference. Because quite frankly, I think your accusation is against the prosecutor amounts to your attempt to obstruct these proceedings. So explain to me, which in and of itself would be grievable, counsel. So explain to me what happened now that you know that they're there, how that changed the whole mindset.
The proceeding with statements that would exclusively be inadmissible at trial and going forward on those. These are confrontation clause issues.
There's a statute which covers that.
I understand that, Your Honor. My concern was it goes to circuit court on those statements, and now they can't proceed to trial. Because at that point, confrontation is going to attach at trial.
So why would that be grievable? If they proceed pursuant to a statute promulgated in the state, as well as a court rule, which covers that, why would that be grievable at any point?
My concern was not determining the facts of the case that they're going to present evidence in today.
If they believe those facts that, but for a hearsay objection, would come in, that not at all goes to their determination of the facts. They may believe that to be the case.
I understand.
So how would that even come into play?
Judge's frustration sharpens as the defense struggles to justify why the grievance threat was made in the first place. Every attempt to explain only makes the situation more precarious. The judge presses point after point, revealing how weak the attorney's foundation really is. This segment is powerful because it shows the courtroom shifting from legal debate to questioning professionalism itself.
Mr. Bennett, how does that even come into play?
I explained what my position is. I don't know what else to say.
Okay, let me just say this. I don't care if somebody's on the defense. I don't care if somebody's on the prosecution side. It doesn't matter to me, especially between counts. No one is ever going to come into this courtroom and be intimidated in some way by some threat to their profession, particularly in proceeding with what is their obligation. It is Ms. Hughes's obligation to bring this case. It is your obligation to defend your client. She can't make threats to you to try to prevent you from proceeding to defend your client, or to do nothing if your client wishes that for you to do that as the defendant. That behavior, Mr. Bennett, is inexcusable in this court's mind. Absolutely inexcusable. And quite frankly, sanctionable. Because you can't try to make somebody not do something by, quite frankly, as I'm listening to your explanation, are just absolutely unequivocally false threats to their livelihood.
I don't believe that's what I was doing.
What do you think you were doing?
Trying to bring to Ms. Hughes' attention an issue that may or may not exist. She interpreted it as a threat, which I understand.
I'm going to grieve your boss and you
I did not.
if you start this exam. She's supposed to take that as something that should be brought to her attention as opposed to a threat.
We continued our discussion a second time where I was explaining where I was coming from.
The judge delivers one of the toughest confrontations yet. She makes it clear that she doesn't care which side someone is on. No one threatens another lawyer's livelihood to influence a case. Her words cut straight through the tension as she labels the defense's actions inexcusable and sanctionable. Watching the attorney attempt damage control under that pressure adds an intense layer of suspense.
I did not say what I said in a very artful way. So
You threatened a grievance for her proceeding. Am I wrong in that?
I didn't consider that I threatened it. I was trying to bring an issue forward. She took this threat.
She took it as a threat. What was she supposed to take it as?
She took it how she took it. I mean, it was a mistake on my part. I acknowledge that.
You're trying to tell this court that you didn't intend to threaten her boss and ultimately her? Is that what you're telling me, Mr. Bennett?
I was trying to bring the nature of what I saw as a potential issue. I unfortunately started it.
The issue being what? Their use of evidence pursuant to the court rule, which is why we have these hearings, why you have the ability to object, and then this court would have to rule.
I felt this case was different because this is not a situation where the alleged victim is given another detailed statement as to what happened.
And so what makes that different?
The duty to investigate the facts.
How do you know they haven't?
besides her telling me that they haven't, I don't know.
I don't know who the per is, but I've never told him the information. I've never told him about the many contacts that she's had with my office. I've never told him about, he's put on the record that she's been appearing at the hearings. Your Honor, she's been at hearings that Your Honor has presided over. The letter that was turned over to the police department was then turned over to the defense. And frankly, he has never asked me. He just came forward with, I'm going to grieve Ellie Sabat.
Mr. Bennett, I am very concerned. What was your intent on saying that?
My intent in this.
You know, I'm going to stop you right now because I'm going to tell you something. You need to be real careful because I may have to consider grieving you.
I understand that, Your Honor.
And I don't think you want that.
This section showcases the emotional unraveling of the defense attorney. He admits mistakes, but still tries to reframe his intent, only to be met with the judge's escalating warnings. When she states she may have to grieve him herself, the air changes instantly. You can see the realization hit him. This has gone far beyond a misunderstanding and into real professional danger.
I certainly don't want that.
So what I'm going to do is I'm going to take another about 10-minute break. And I'm going to come out and ask for your explanation before I decide on anything that I would do. But I will let you know, Mr. Bennett, with regard to what I've heard of the conduct here, you are walking on real thin ice, not just with me, but with your ticket to practice. Court's in recess.
All rise.
Back on the record in the case of the people, State of Michigan versus Whitley, counsel is present as well as the defendant. Is there anything else regarding this issue that either side would like to say?
Your Honor, I'm going to self-report the violation under Michigan Rule of Professional Conduct, subsection A. I agree that I gave the inappropriate message to the prosecutor. I apologize for doing that. I feel obligated to report myself.
We will see if that happens because the court hasn't made a decision as to whether or not the court should report you. Mr. Bennett, I am going to tell you in all the years I've been here, counsel, and even when I was down in the trenches, counsels say things to each other, maybe not meaningful necessarily. They'll say things out of anger to each other. I don't know why you would even think it would be.
After the recess, the attorney returns with a surprising move. He voluntarily announces he will self-report his conduct. The judge, however, isn't immediately persuaded and notes she must decide whether she should file a report as well. Her disappointment is clear as she reflects on years of courtroom experience. Stunned that an attorney would ever make a threat of this nature, the gravity deepens.
To make that kind of threat. And I call it a threat. That's precisely what you were doing. And I have to make a decision now knowing it as to whether or not I should do it. And I will make that decision. Ms. Hughes, and I'm going to apologize on behalf of the court for having to do this, but I think it's necessary given this turn of events. Would your lay witness, as well as I guess the officers, would they be available on July 1st at 10?
Is it at all possible to have the lay witness testify? It would be to identification. And I would.
As to identification of
The defendant. So it's very brief. And I don't want to have to bring the lay person back.
understand. Mr. Bennett.
I would stipulate to the identification.
So you're stipulating that the person that is sitting beside you is James Whitley, and that he was in a relationship with Jennifer Potter on April 27th, 2024.
Yes.
Thank you.
Will that satisfy what that witness would testify to?
Yes.
Very good. Thank you.
What was the date? I apologize.
I am going to adjourn this, if it will work for everybody, to July 1st at 10 a.m. That is my only.
July 1st at 10 a.m.
I realize
Intensity eases into procedure as the judge arranges new scheduling, and the defense stipulates identification to avoid recalling witnesses. But the shadow of the earlier conflict still hangs in the air. Everyone knows the judge's upcoming decision could have serious consequences. And that wraps up this breakdown of a tense, unfolding courtroom drama. If you enjoyed this deep dive, make sure to like the video, subscribe to the channel, and we'll see you in the next one.